I'm Rebecca Patey, and I'm an Assistant Attorney General for the state of Alabama with the Alabama Department of Environmental Management. I'm also a very proud Crory adjunct professor, and I am proud to be presenting at this conference for Fidelis University in San Jose, Costa Rica. My topic is the Clean Water Act, an overview of the Supreme Court cases interpreting waters of the United States. In 1972, with the passage of the Clean Water Act, Congress defined navigable waters as waters of the United States, including the territorial seas. Then left it up to the EPA and the United States Army Corps of Engineers to further define the term WOTUS, waters of the United States. Given the vital importance of water to the United States and all that would be riding on the regulatory interpretation of the WOTUS definition, it's no wonder the definition has remained a litigious flashpoint between the two federal agencies charged with implementing the Clean Water Act and then by de facto their state agency counterparts. The section that causes all the kerfuffle. Clean Water Act Section 404, codified at 33 U.S. Code Section 1344, requires permits for the discharge of dredge or fill materials into navigable waters, which is defined by the Act as 5 words, waters of the United States. This provision is the basis for the federal wetlands permitting program. We will be covering 3 cases. There are many, many more. And if I had more time, I would love to go through them all with you. In fact, I wrote an article uh, that extensively goes into all the cases, and actually, because I'm a Sopranos fan, has a Soprano slant to it. But it covers all of them in detail. And I'll provide my email at the end should you have any interest in wanting to read in detail about all the cases. But the 3 we're going to cover, I've provided the legal sites: Solid Waste Agency of North Cook County versus Army Corps of Engineers, SWANK; Rapanos versus the United States, known as Rapanos; and Sackett versus EPA. Long before the Swank case, as I previously alluded to, but can't mention enough, there have been controversy and litigation over whether isolated waters that are not adjacent to true navigable waters are properly within that section we went over, Section 404. Are they to be regulated, or can people do with them what they will? In 1985, the Supreme Court sustained the assertion by the Army Corps of Engineers and the EPA that waters and wetlands adjacent to navigable waters, navigable interstate waters, or their tributaries are in fact waters of the United States under Section 404. The question left for the Swank case, for the United States Supreme Court in the Swank case we're discussing, is whether waters and wetlands not so adjacent, isolated waters, were they also covered? The facts in the Swank case are this. Solid Waste Agency of North Cook County selected an abandoned sand and gravel pit as a solid waste disposal site. And because it had been abandoned, certainly water had gathered in it over the years, and it had become a pond of sorts for migratory birds. And the Swank, in order to put in the landfill, needed to fill what was that formerly abandoned site, and sought to get a determination from the Army Corps of Engineers whether they would need a permit. And the Corps, in that instance, denied the permit. Under the Clean Water Act, navigable waters are defined as WOTUS, and the Corps regulations define waters that impact intrastate, interstate, but of which damage could affect interstate waters. So subsequently, even though it was a standalone abandoned sand and gravel pit that had just gathered natural water, that it was covered under Section 404, and therefore the Army Corps of Engineers denied that permit, and Swank appealed all the way to the United States Supreme Court. The issue before the U.S. Supreme Court was, made the provisions of the Clean Water Act be extended to intrastate waters, and then beyond that to those so-called isolated waters, and did Congress even have the power to do so under the Commerce Clause? The opinion of the court was no, it didn't extend to those isolated waters, and then they left unanswered whether Congress had the power under the Commerce Clause to regulate. In a 5-4 opinion delivered by Chief Justice William Rehnquist, at the time, then Chief Justice, the court held that the provisions of the Clean Water Act, which require those discharge fill materials into navigable waters to obtain a permit from the Corps, does not extend to isolated, abandoned sand and gravel pits with seasonal ponds which provide migratory bird habits. This was known as the migratory bird rule for years, and that was what we began the EPA, Army Corps, state agencies began to regulate, was that these so-called isolated waters could not be regulated. Writing for the majority, Rehnquist said that the term navigable has import, and showing what Congress had in mind, that really its traditional jurisdiction over over waters that were actually navigable, ships could go in, or which could reasonably be made navigable. And so you can see they're an isolated pond, even though the birds used it quite happily, I'm sure, would not be considered a true water of the United States. So that was the Swank case. Um, Now to the Rapanos case. This case involved developers John Rapanos and June Carabel, whose separate projects were stopped because of environmental regulations that make up the Clean Water Act. In the late 1980s, Rapanos filled 22 acres of wetland that he owned with sand in preparation for the construction of a mall without filing for a permit. He argued that the land was not a wetland and that he was not breaking the law. But his own consultant and state employees of the Michigan Environmental Protection Agency disagreed. Rapanos claimed that his land was up to 20 miles away from any navigable waters. However, the term navigable waterway has been broadly interpreted by the EPA and all regulatory state environmental agencies to include those areas connected or linked to via tributaries or other means, even man-made means. And so Rapanos was convicted of 2 criminal felonies for filling wetlands without a permit. He appealed. So some of the issues left open by the Swank case about the isolated waters were, true air quotes, resolved with a wink and a nod and a head slap by the U.S. Supreme Court in the ruling in the Rapanos case we're discussing now. In Rapanos, the court further narrowed the scope of the term waters of the United States, which include only those relatively permanent, standing, or continuously flowing bodies of water forming geographic features that are described in ordinary parlance as streams, lakes, oceans, rivers. Not the tributaries, not the standalone sand and gravel pit of Swank. So the court is narrowing the waters that are to be protected as waters of the United States. Rapanos was a U.S. Supreme Court case challenging the jurisdiction to regulate isolated wetlands, because that question was left open by Swank. It was the first major environmental case heard by our then newly appointed and current Chief Justice John Roberts and a newly appointed Associate Justice Samuel Alito. While 5 justices agreed in the result that to void the rulings against the plaintiffs, Rapanos and Carabel, to dismiss their convictions because they were they just they had filled their wetlands to build a shopping mall without obtaining permits from the Corps of Engineers. But the court, well, they agreed that their wetlands were not covered by Section 404 of the Clean Water Act. They agreed on the outcome, but of the 5 justices in that opinion, they did not all agree on how to get there. 4 of them agreed in a plurality opinion, and one of them, Justice Anthony Kennedy, he didn't agree with the liberals, who did not prevail in the case, the liberal justices, or really with the opinion of the conservative justices that did prevail. He agreed in the outcome, but not how they got there, making it very, very confusing to regulate under. The issue before the court in Rapanos was, does the phrase waters of the United States in the Clean Water Act include a wetland that at least occasionally empties into a tributary of a traditionally navigable water, providing protection for that water? Well, as I told you, unanswered, which is not a great way to have case law. And in the ensuing years between this case and the next case we're going to talk about, the Sackett case, attempt to regulate, because the plurality opinion was written by former Justice Antonin Scalia. He was joined by 3 other justices, so that made 4. And he said, the plurality agreed that their definition of the term of waters of the United States could only refer to relatively permanent, standing or flowing bodies of water, not occasional, not intermittent, not inferior flows. Furthermore, just a mere hydrological connection to a wetland as covered by the Clean Water Act would not be covered. In order for it to be a wetland to be covered under the Rapanos plurality definition, it would need to have a continuous surface connection with a true navigable water of the state. Justice Kennedy, though, in agreeing again with the outcome, said no, the test should be significant nexus. He wrote a separate concurring opinion in which he disagreed with much of the plurality's reasoning. In Justice Kennedy's view, wetlands need not have a continuous surface connection to a continuously flowing body of water to be covered under the Clean Water Act, but merely adjacency to a tributary of a navigable water is not sufficient. Instead, wetlands that are not adjacent to a traditionally navigable water must have a significant nexus with one. So his test was not continuous surface connection. His test was significant nexus. And you could tell that his test, his requirement, in order to be satisfied for the wetland to be regulable under Section 404, had to have a significant effect on the water quality of the navigable water. Be significant nexus to them and a significant impact. 2 tests came out of Rapanos. And because it was a strange plurality, the 414, that's why it was really unanswered. We had two tests, and under our law, either one during the years that Rapanos was the law of the land, arguably either test could be applied. It was almost circuit to circuit, state to state. Really difficult times. And now we arrive at the Sackett case, which is the current law of the land. The Sacketts owned a half-acre lot in a residential area near Priest Lake, Idaho, and they filled about 1 acre of that property with dirt and rock in preparation for building a house. The EPA issued a compliance order against the Sacketts. The compliance order alleged that the parcel is a wetland subject to the Clean Water Act and that the Sacketts violated the Clean Water Act by filling in their property without first obtaining a permit. The order required the Sacketts to remove the fill material and restore their parcel to its original condition. They, of course, sought a hearing with EPA to challenge that. And the EPA denied that hearing, and the Sacketts appealed for injunctive and declaratory relief. The issue before the United States Supreme Court was, do landowners have a right to go to court to challenge a Clean Water Act order of the EPA? And the court, while finding yes they do, revisited the Rapanos difficulties with Samuel Alito now having, because of the retirement of Justice Kennedy, now having 5 judges that agreed with the continuous flowing bodies of water forming geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes. So out went the significant nexus Kennedy test, and the law of the land as it stands today in 2023. This case was decided in 2023. We're in 2024 now. It has not been changed. So the law of the land now is the court held that waters are not protected by the Clean Water Act unless they have a continuous surface connection to key lakes, rivers that affect interstate commerce. This means the waters that have underground connections to lakes, or even waters that are tributaries or impact lakes and rivers by man-made barriers, no longer covered. You can fill them in without having to apply for a permit. As you can imagine, environmental groups were apoplectic when this ruling came out. And it made it much harder, or limited the scope of what EPA, the Corps of Engineers, and certainly state agencies could regulate. In fact, the environmental advocacy group Earth Justice claims that over 59 million acres of wetlands are threatened by this ruling. The EPA and the Army Corps of Engineers introduced their proposed final rules on wetlands, reflecting this current Sackett opinion of the Supreme Court in August 2023. The rule reduces the number of wetlands covered by federal law and leaves to the states only a small degree of perhaps possible more protection of wetlands not covered. Thank you for your time. I hope that you've enjoyed the presentation. I know I couldn't go as in depth during the time that I had, but I'm certainly grateful for the chance and opportunity to present and hopefully pique your interest. This is my bio, but the most important thing there, other than that I teach at the Troy University, is my Troy email, and I provided a Gmail. Should you have any questions or want to ask anything in more detail, or see the more detailed article I wrote with the Sopranos slant to it. I thank you so much for your time. I wish I could be there in Costa Rica with you. Have a blessed and wonderful time.